All right, ladies and gentlemen, I'd like to open the 120th meeting of the First Committee of Inquiry of this electoral term. The public has been established, and the media and the press representatives and the public are welcome. Again, I thank everyone for their reports. Before we speak about the subject matter of this meeting, please allow me some introductory remarks. There will be no audio or video recording during this meeting. This is also true for this hearing, not just a general rule. Due to the great public interest, the committee decided, in accordance with Section 13 of the law of the Committee of Inquiry, to allow videotaping of this meeting by the Bundestag's administration. This videotaping will also be broadcast live on Bundestag CCTV. Other audio and video recording is not allowed during the meeting, so please switch off all your devices. Should you violate this stipulation, you may be excluded permanently from the meetings of this committee and the entire House. It can also have consequences under criminal law. In the 120th meeting of the First Committee, we will have a public hearing based on the decision to take evidence SV17 and SV18. We will take evidence on the subject under investigation, Bundestag printed matter 18843 and 188683, by hearing expert witnesses from the United Kingdom. This hearing will be an open hearing exclusively. That is the plan, and I'm sure this is what we will do. I would like to welcome our experts in alphabetical order. First of all, Richard Aldrich, Professor for International Security at the University of Warwick. Very warm welcome to you, sir. David Anderson, independent reviewer of terrorism legislation. Silkie Carlo, Policy Officer in Technology and Surveillance with the NGO Liberty, and Ben Jaffey, Barrister for Blackstone Chambers. All right, welcome to all of you, and thank you for accepting our invitation and for being willing to make this journey in order to speak here to us as expert witness. This is the only parliamentary committee of inquiry dealing with this very issue related to the Snowden revelations. And so we are very pleased that you're giving us the opportunity to get a clearer overview and a clearer understanding. We're not just looking backwards, we're not just looking with retrospect on what has happened. We always want to look into the future to see what can be improved, what can be changed in order to improve privacy, data privacy, but also data protection. The good thing is that the United Kingdom is part of Europe, right now at least, and so there might be some opportunities that they continue to be a part of Europe in one way or another. And so we have the opportunity to speak in the same legal area, as it were, about the intelligence services in the United Kingdom. It's a little harder with the United States because it is a different legal area. So the UK is a different situation, and in terms of the content, in terms of subject matter, we might not always see eye to eye, but I think together we can get things moving. So it is very important for us to learn about the situation in the United Kingdom. I have to point out to you that the Bundestag administration will make an audio recording of this meeting as well. This is only used in order to facilitate the stenographic record of this meeting, and this audio recording will be deleted subsequently. The minutes of this meeting will be forwarded to you, and if necessary, you have 2 weeks for any corrections or amendments in case anything has been recorded wrongly, or if there are any corrections you would like to make and to make sure that the minutes are correct. If you handed in a written statement, these written statements will be published on the website of the Committee of Inquiry right now as we speak. So your statements will be accessible on the Bundestag's website. Ms. Carlo, gentlemen, do you have any questions so far? Wonderful, thank you. Dear experts, before you give evidence, I'm obliged to caution you. experts have to be cautioned as well. You have been summoned as expert witnesses. As expert witnesses, you are bound to tell the truth. Your testimony must be impartial and given to the best of your knowledge and belief. I also have to caution you against the possible consequences under criminal law should you fail to tell the truth. Under sections 162 and 153 of the German Criminal Code, whoever gives false, unsworn testimony before a committee of inquiry shall be liable to imprisonment from 3 months to 5 years or a fine. Under sections 28 and 22, paragraph 2 of the Committee of Inquiry Act, you may, however, refuse to provide information in response to questions if answering those questions would expose you or persons related to you within the meaning of section 52(1) of the German Code of Criminal Procedure to the risk of investigation under due process of law. This refers, theoretically, but this refers to investigations due to criminal offenses, according to the legal regulations not only of Germany but also of your home country, and could also lead to administrative office offenses. Should you have any questions regarding the legal situation here in Germany, if anything is unclear, please chime in at any time and ask us, ask the Secretariat, ask me as Chairman to clarify the situation. Do you have any questions so far? Wonderful, thank you. After this introduction, let me briefly explain the planned procedure of this hearing. According to sections 28 and 24(4) of the Committee of Inquiry Act, you will be given the opportunity to speak in context on the matter under investigation, so you will be able to give an introductory statement. The order will take place in alphabetical order, in the order you are seated, which is alphabetical. And I would also like to stick to a time period of 10 minutes each for your introductory statement. I know it's not always easy, it's a very comprehensive subject we want to discuss, but it is important because we want to have enough time for questions and answers. After that, the parliamentary groups will be given the opportunity to ask questions. Every member has the opportunity to ask questions. It will be either 2 questions to the same expert or 1 question to 2 experts each. So this is the customary procedure here in the German Bundestag, and this is what we do in our committee as well. So we will have 1 round of questions covering all 4 parliamentary groups, and we will have the opportunity to answer, followed by the next round of questions and so on, until all questions will be answered. This hearing will be over at 2:50, 3 p.m., because at 3 p.m. we will hear another witness in another public hearing. And I know that Mr. Anderson has to leave a little earlier. He has some prior commitments, so he has to leave at 2 o'clock, and we should bear this in mind when we ask our questions. Today, we will speak about the parliamentary, public and scientific debate in the United Kingdom on the activities of intelligence services based in the UK when it comes to SIGINT, their parliamentary oversight and the protection of liberty and privacy, in particular with respect to possible changes to the legal situation following the Snowden revelations in 2013, with respect to legal entitlement and possible protection against the acquisition, retention, and passing on of data from telecommunication, the telecommunication field, and their use. So it is a very comprehensive subject, as you know, but this is how these decisions to take evidence were worded at the time. So we hope to learn from you regarding this field, because it is the subject matter of this, of the mandate of this committee. So, should there be no further questions, I would like to move on to the introductory statement, and we proceed in the alphabetical order. So Mr. Aldrich would be the first one to speak to us. I give you 10 minutes to speak on this matter, and also maybe to respond to the questions that were already forwarded to you. Sir, the floor is yours. Thank you.
Can I begin by thanking you for inviting me to come and speak to you today? It's a great privilege to be here. I'd like to begin with a singular fact. IBM tells us that 90% of the data in the world has been created in the last 2 years. And that tells us something about the the exponential curve that we are on. Many people assume that the internet revolution has arrived, that the communications revolution has happened. In fact, it is just beginning. We're at the beginning of an exponential curve that creates some very serious challenges. And I'm delighted that you're looking at this issue today precisely for that reason. I'm also perhaps rather more optimistic than many other people about the nature of these challenges, because although these changes mean less privacy for the individual, I also think they mean less confidentiality for corporations, and they mean less secrecy for government. And if they're managed in an appropriate way, if the ownership of this data is horizontal, the future might be quite nice, not so nasty as some people suspect. Just a few remarks about the journey that intelligence has been on over the last 20, 30 years. In the 20th century, intelligence was owned by states. I would say it's now owned by corporations, because the main target of intelligence services are people. And their communications, their data are mostly held by banks, airlines, supermarkets, ISP providers. So it's entirely natural, perhaps even necessary, that the intelligence agencies should have taken an interest in those sorts of data sets. I think in 20 years' time, intelligence will migrate again. In the 20th century, intelligence was owned by states. It's now owned by corporations. In the future, it will be owned by individual citizens. And this was illustrated by the attacks on the Boston Marathon, when individuals with mobile phones took the lead in the search for the perpetrators. This flattening of data also means challenges in terms of secrecy for intelligence agencies, and the Snowden revelations are an example of that. The CIA have stated publicly that they no longer feel they have secrecy. All they have is delayed disclosure. So that is changing the operational field for intelligence agencies, it's changing the nature of secrecy, and it's changing the nature of intelligence oversight. It's quite clear that over the last 10, 15 years, many of the formal oversight bodies created in the United States and Europe had failed to pick up things like secret prisons, but a more informal pattern of oversight generated by civil society, whistleblowers, journalists, academics, campaign groups, lawyers, NGOs, the European Union, the United Nations, stepped in and did a better job. I would describe this as ambient oversight. It's a different form of oversight in which whistleblowers have played a very important part. The decline of secrecy and the role of whistleblowers, I would suggest, needs careful management. I'm conscious that for researchers like myself, people like Edward Snowden have been very welcome. They've told us, they've given us a great deal of interesting information, but the way in which that information is released is potentially harmful. And I would argue that one of the unintended consequences of the Snowden revelations is that many states around the world which have repellent political attitudes have taken a great interest in the Snowden revelations and are busy buying up new technology, moving into the field of electronic surveillance, and they're very keen to acquire capabilities which, before the Snowden revelations, they were unaware of. So I welcome the work of whistleblowers, but the way and the place in which they blow the whistle is something which needs careful attention. I think the other thing that I'd like to talk about in terms of the future is the importance of encryption. It's pretty clear that technologists regard the way in which states handle the issue of encryption, private encryption, as a key test of liberality and humanity for democratic states. I have to say the UK is not responding to this challenge particularly well. But I think perhaps in 10 years' time we'll look back at the Snowden revelations and see this as the high point of mass collection, of mass interception. Perhaps in 10 years' time we'll see a situation where end-to-end encryption is restricting access to content, and intelligence activity will be conducted largely around metadata. Perhaps that will be a reasonable compromise, but the interesting thing about this compromise is that it won't be determined by parliaments, by public debate, by consensus. It will perhaps be delivered by some new algorithm developed by a 19-year-old maths graduate in Berlin or Heidelberg. In other words, there's a disconnect between the way in which these balances are being generated technologically and our public debate. Just some recommendations to close my presentation. As I say, these changes present challenges for society, for Parliament, particularly for oversight, and I don't think oversight has worked particularly well over the last 10, 15 years. So I think it's really important that formal oversight bodies have more researchers. Research power is clearly very important in investigating these things. I'd also urge you to look at the possibility of inspectors general. This is not something that the UK has, but certainly countries like Australia, Canada have inspectors general, and I think they're a much more appropriate recipient for whistleblowers. I find the case of Thomas Drake particularly striking. Thomas Drake was an NSA, a senior NSA employee and a whistleblower, and he looked for every possible avenue. His managers, ombudsman, people in Congress, before he went public with his revelations. And that shows us that we're not handling whistleblowers very well. I think inspectors general would be a good opportunity. I think it's important that we broaden the composition of oversight bodies. We should see not only politicians, but also lawyers, academics, journalists, people from NGOs. And most importantly, I think we should try and separate out the functions. In many countries, oversight bodies are responsible for both efficiency and lawfulness. This is certainly the case in the UK. Some of the oversight bodies are looking at efficiency and effectiveness, but also lawfulness and ethics. And I would argue that represents a conflict of interest. That closes my statement. Thank you.
Ganz herzlichen Dank. Sehr gut in der Zeit.
Thank you very much, and thank you for adhering to the 10 minutes. Mr. Anderson, you're next. Please, the floor is yours, sir.
May I start, Professor Sensburg, by agreeing with you that I am delighted that the United Kingdom and Germany are in the same legal area, particularly where human rights are concerned. In these difficult times, it seems to me very important that in that respect, as in others, we stick together. Now, I am a lawyer independent of government. That is perhaps already evident to you. I was asked by the Prime Minister to do 2 reports, one in 2014 to 15, one in 2016, which have informed the very new act governing surveillance that received its final assent and became law on Tuesday of this week. It's an act of more than 300 pages. 2.5 years ago, when I came to the surveillance debate, post-Snowden, it struck me as a very emotional debate. The privacy advocates were accusing the government of deceit. We never knew you did this stuff. You didn't tell Parliament. You are trying to control us. And on the other side, you had security people saying, you are unpatriotic. They are only trying to keep you safe. I think we have moved past that stage in our country. And if you want my reason why we have managed to do that in one word, it is transparency. This was the central recommendation of my report, but my report is not the only reason. Mr. Snowden, whose actions I do not condone, produced a lot of evidence which lawyers like Mr. Jaffey took to our courts in the United Kingdom and got rulings that unless these powers were made fully transparent, they did not have the quality of law. The penny dropped, and that is why I believe that our new law sets a world-leading standard for transparency. You will find powers detailed in that law, for example, the state power to hack devices, networks, and systems, which I have reason to believe are practiced by other countries as well, but which do not appear so clearly or at all in their laws. And as soon as we had transparency, as soon as the bill was published, the debate changed. It was no longer, you deceived us. The debate became, where is the operational case for this power? Or don't we need more safeguards on that one? And in my opinion, in a healthy democracy, that is where we should be. Are the safeguards in our bill enough? I don't know, but we may learn from the Court of Justice of the European Union on the 21st of December, in another of Mr. Jaffey's cases, whether that is so. I move to my second report, which was produced this summer during the passage of the bill. I was asked really by our opposition, Labour Party, and then by the Prime Minister, to report on the operational case for the bulk powers. These are the powers used only by intelligence agencies that involve the collection of material, some of which relates to people who are not under suspicion. So powers that are very controversial. I spent 3 months with a skilled team with different expertise at the intelligence agencies, interrogating them, looking at documents. And if any of you are interested in this question of bulk collection and bulk powers, I commend to you my report of August 2016. It's on my website, and I've provided a link to the committee. I'd be prepared also to provide you with a hard copy, if that would be useful. But what you find in that report is 60 or 70 case studies of instances in which these powers have been useful. In cyber defense, extremely important, against hostile foreign states. In warfare, against terrorism, against child sexual abuse, against serious and organized crime. Now, I read this morning a tweet from a highly respected German journalist who said we were going to be talking today about mass surveillance. And I thought I would just mention that that phrase, mass surveillance, is one which none of the political parties in the United Kingdom adopted when they were talking about these issues, even those who were in principle opposed to the bill. They talked about bulk collection, and they were quite right to do that, but they did not talk about mass surveillance. Let me talk to you very personally as someone who I hope is independent. I haven't drunk the Kool-Aid, but I have spent a lot of time inside GCHQ, inside MI6, inside MI5. The people I met at GCHQ, if they were not working there, they would be writing computer games, they would be sitting in their bedroom hacking NASA, or they would be earning 4 times the money working in the City of London or in Silicon Valley. The idea that those people are trying to keep our population under some kind of total surveillance, let alone the population of a friendly country such as Germany, I'm afraid seems to me quite ludicrous. Now, that is not an argument against rigorous safeguards. I am in the forefront of those arguing for rigorous safeguards, and I think you'll find when you look at our bill that the safeguards are much stronger than they were, and quite right too. I want strong institutional safeguards and not a series of whistleblowers who may do good, incidentally, but can also do a lot of harm. But it is, at least in my opinion, an argument in favour of having powers which can play an important part in keeping us all safe. And I should say that another thing I've learned, and this is my final point, is just the extent to which we depend on each other. I have seen how British forces in Afghanistan have had lives saved by the use of German intelligence. I have also seen examples of incidents in Germany, including quite recent incidents, in which without the assistance of foreign intelligence partners, German lives would have been lost. That cooperation, I'm quite sure, is something that will survive whatever politics throws at us over the next 2 or 3 years. Thank you.
Ganz herzlichen Dank, Herr Anderson, für Ihre Ausführungen. Und wir kommen jetzt
Thank you, Mr. Anderson.
Frau Carlo.
Ms. Carlo, please. The floor is yours, ma'am. Thank you.
Thank you, and it's a real privilege to be here. Liberty welcomes the opportunity to engage with the Bundestag Committee of Inquiry on the subject of international mass surveillance, which is a term that we do use positively and that we have found that opposition parties do continue to use for good reason, as revealed by NSA whistleblower Edward Snowden. Liberty is also known as the National Council for Civil Liberties, and it's a membership organisation founded in 1934 that campaigns for civil liberties and human rights in the UK. Liberty has and continues to campaign against suspicionless and mass surveillance through the courts, in Parliament and in the wider community. I'm a policy officer at Liberty and I specialise in technology and surveillance. The British government has enacted new overarching legislation on surveillance, as you've heard, the Investigatory Powers Act, which was enacted on the 29th of November 2016. Liberty closely followed the progress of the bill through Parliament, lobbying for amendments to a raft of powers that we view contravene human rights, law and democratic principles. And we now plan to mount a public interest legal challenge to the legislation in the courts. This legislation is widely understood to be a response to the public controversy and litigation arising from the Snowden revelations of GCHQ and Five Eyes mass surveillance, bringing British security and intelligence agencies' secret practices within the rule of law. Thus, the government has described the legislation as world-leading, as you've already heard, and exemplary for other democracies. However, if there's one thing that I hope to strongly convey today, it's that Liberty strongly urges against such perception of the legislation, as in our view, it is plainly in breach of fundamental human rights and obligations under the European Convention on Human Rights and the Charter of Fundamental Rights of the European Union, respectively. Several of the powers legislated in the Investigatory Powers Act are currently being challenged in the courts. While many of these powers were not previously provided for in legislation, challenges were able to be mounted as a result of the Snowden disclosures, despite the UK government continuing its neither confirm nor deny stance. Notably, in the 10 NGOs case, which you'll hear more about from Mr. Jaffey, which is currently being considered at the European Court of Human Rights, Liberty is challenging bulk interception as practiced under the Regulation of Investigatory Powers Act 2000, or RIPA. In addition, Liberty is acting on behalf of Tom Watson MP in the Watson case, challenging the compatibility of communications data, or metadata, surveillance practices under RIPA and the Data Retention and Investigatory Powers Act 2014, or DRIPA. So we are challenging the compatibility of that with the European Charter. A judgment from the Court of Justice of the European Union is due on the 21st of December of this year. We've already received the Advocate General's opinion on the case, which indicates that institutionally independent authorization for access to communications data, as well as a threshold of serious crime, are necessary safeguards. Unfortunately, neither safeguards are currently within either the pre-existing legislation, DRIPA, or in the recently passed legislation, the Investigatory Powers Act, which will replace DRIPA when DRIPA expires on the 31st of December of this year. To run you through the powers that are in the Investigatory Powers Act, the Act provides for targeted and thematic interception, targeted access to communications data, notices requiring the bulk retention of communications data, targeted and thematic equipment interference or hacking, bulk interception, bulk acquisition of communications data, bulk equipment interference or hacking, the acquisition and retention of bulk personal data sets, which are big data sets on the population and other populations, we presume, with large unidentified sets of people, and widely enabling national security and technical capability notices, forcing telecommunications operators to comply with government orders, including the removal of encryption on services. I'm aware that one of the areas of focus of this committee is oversight mechanisms. The Investigatory Powers Act in the UK provides for new oversight mechanisms via the creation of an Investigatory Powers Commissioner and fellow judicial commissioners who will authorise surveillance warrants where they're provided for in the Act, on the basis of their adherence to correct procedure, because the judicial authorisation is limited to judicial review principles. So they are not merits-based authorisations, they are not merits-based decisions on the suitability of a warrant. Liberty campaigned for a different and improved model of oversight. We believe that oversight bodies should be under a mandatory statutory duty to notify subjects of surveillance once an operation or investigation has ended or once reasonable suspicion of a subject has subsided, for example. We also called for an independent privacy and civil liberties board to be established to promote human rights compliant practice. We believe that expert scrutiny and reporting focused on safeguarding civil liberties would be a very welcome addition to the oversight framework. I'm aware, of course, that another area of focus for the committee is intelligence sharing. We were very disappointed that the Investigatory Powers Act does not address the intelligence sharing relationship between British and foreign intelligence agencies, in particular the Five Eyes. We have a parliamentary committee called the Intelligence and Security Committee, which noted that this legislation does not, therefore, meet the recommendations made in that committee's privacy and security report, and that future legislation must set out these arrangements more explicitly, defining the powers and constraints governing such exchanges. The ISC, that parliamentary committee, has strongly recommended that international data sharing should be included in the Act, remarking that the proportion of intercept material obtained from international partners is such that it is not appropriate to exclude it from legislation which purports to cover interception. However, international intelligence sharing does remain absent from the Act. David Anderson described in the former report that he relayed to you an international trade in intelligence between the Five Eyes partners, the UK, the USA, Canada, Australia, and New Zealand. Insofar as material gathered by the British services is shared with other countries, the report explained that the security services take the view that under their founding statutes, information can be shared if it is necessary for the purpose of the proper discharge of the security and intelligence agency's functions, and that when it is considered that this test is met, certain safeguards apply, and some of those are under RIPA. However, the report concluded that, in practical terms, the safeguards applying to the use of such data are entirely subject to the discretion of the Secretary of State. This would seem to remain the case under the Investigatory Powers Act. And David Anderson's report recommended that information sharing with foreign countries should be subject to strict, clearly defined and published safeguards, and we concur with that view. His report added that the new law should make it clear that neither receipt nor transfer of data should ever be permitted or practiced for the purpose of circumventing safeguards on the use of such material in the UK. Such safeguards and guarantees are notably absent from our new legislation, the Investigatory Powers Act. Liberty concurs that intelligence sharing with foreign countries should be subject to strict, clearly defined and published statutory safeguards. This would be a vital safeguard against abuses of international data sharing to evade safeguards in domestic law. In our view, an essential safeguard to international intelligence sharing must be a prohibition on sharing intelligence where there is a risk that it could facilitate actions that would be unlawful domestically. This would help us protect against the risk that UK intelligence may lead to human rights abuses overseas, such as torture or execution. I'll end my introductory statement there and look forward to taking questions with the rest of the panel, and also would be very happy to follow up with any written evidence if you should request it. Thank you.
Ganz herzlichen Dank für Ihre Ausführungen.
Thank you very much for these explanations, Mrs. Carlo. Now, you, last but not least, Mr. Jaffey, please.
Thank you very much again for your invitation. I can offer a practical perspective on the operation of the current oversight system in the United Kingdom and how UK oversight of particularly bulk surveillance activities in practice works. My experience is in acting mainly for claimants in a number of courts and tribunals, but in particular the Investigatory Powers Tribunal, which is the specialist UK court that deals with surveillance issues. Since the Edward Snowden revelations, there have been a number of cases in the Investigatory Powers Tribunal analysing whether or not the conduct of the UK security and intelligence services has been lawful. The first point is that whatever anyone may think of Edward Snowden, whether you think his head should be on a spike or whether you think there should be a statue and that he's a hero, none of those cases would in practice have ever been possible were it not for the disclosures which he made. So they were the trigger for a lot of litigation. What the tribunal has done is, as David Anderson has pointed out, it has decided that there needs to be a great deal more transparency about the activities of the security and intelligence services, and that if, in general terms, the nature of the powers they're exercising and what they're doing is not made public, then that will be unlawful under the European Convention on Human Rights. And so in relation to past conduct of the security and intelligence services, some breaches of the convention have been found. The tribunal has also decided that the UK security and intelligence services were not properly protecting the right to legal professional privilege, the right of an individual to consult their lawyer in private. And so in one case where an individual or two families were suing the security and intelligence services, a finding was made against GCHQ because GCHQ had collected legally privileged information belonging to one of those families. There have also been other findings against the security and intelligence services, usually in relation to the quality of the oversight which there was over them in the past. What the tribunal has done is it has led to a considerably greater amount of transparency as to what the agencies are doing, quite a lot of public disclosure and public debate, and also substantial changes to their working practices going forward. What are the useful lessons that can be learned from that 2 or 3 years of legal proceedings? I think there are two important issues that have come up. The first one is the real risk of secret interpretations of the law. Laws about surveillance generally are worded broadly. They give fairly extensive powers and a lot of discretion. It is possible for a government or a security and intelligence service to interpret those powers very broadly. If the police decide to interpret their powers of search broadly and come and kick down my door whilst I'm sleeping at 6 o'clock in the morning, I know what they've done, and then I can go to court and I can challenge it. The particular challenge of oversight of the security intelligence services is that most of their work necessarily has to be done in secret. And so if they adopt an aggressive, broad interpretation of the law, that won't be publicly known. So an important part of any effective oversight system is to bring those interpretations of the law to the public so that they can be effectively challenged in court proceedings. What my experience of doing litigation has shown does not work is it isn't good enough to have a system where you have a judge or a retired judge look at those secret interpretations and decide if they're okay or not. Without a system of adversarial challenge where both sides of the argument get to be heard, preferably in public, about whether or not those interpretations are right or wrong, you generally don't get to good answers. And the reason for that is that judges require the assistance of lawyers and argument in order to be able to understand the strength of the arguments on both sides. And the truth is, in the United Kingdom, most judges are old enough to have grandchildren, and they're the people who they need to ask how to operate and assist them with modern technology. And so without the benefit of public evidence and public argument, it is quite difficult to have good surveillance oversight. The other thing is, well, I've said them both, but for the future, I think there are 3 points that are important. The first point as to what's going to happen in the future is what the requirements of EU law are going to be governing surveillance. There are already important decisions of the Court of Justice of the European Union about surveillance, and there are going to be many more. It's unclear at the moment whether or not prior independent authorization is required for access to communications data, for metadata, and how much and how long there should be retention of data. Those issues are very much up in the air. Secondly, an important issue for the future will be the sharing of data in bulk between intelligence services. That will be particularly important if, for example, the United States decides, as the President-elect has said he will, to return to torture. Both this country and the United Kingdom and all the other members of the European Convention on Human Rights have set their face against the use of torture as an interrogation technique. And if we return to the dark days of black sites in 2003 and 2004, after the 9/11 attacks, there will be some very difficult decisions for oversight bodies in this country and in the United Kingdom as to how far the current system of cooperation can continue. Thirdly and finally, there is the issue about the protection of people who are foreigners within the system of the European Convention on Human Rights within Europe. Because at the moment, the United Kingdom Investigatory Powers Tribunal has decided that if someone is not resident in the United Kingdom at the time that any interception takes place, they have no rights under the European Convention. So today, when I'm here in Germany, I can be subjected to interception by GCHQ without the protection of the European Convention. When I land back in London later this evening, I will have the protection of the European Convention on Human Rights. If you choose to visit London, you get that protection. Now, the risk of that is that within the single legal space of the European Convention, it means that one country can conduct operations in respect to the citizens of another country without the minimum baseline protections of the Convention. And there are going to be further important cases in the coming years as to whether or not those interpretations are correct, or whether or not the minimum standards of the Convention ought to apply throughout the legal space across Europe. I hope that's of assistance, and I'd be happy to answer any questions that you have.
Ganz herzlichen Dank.
Many thanks indeed. Let's now move over to questions as described earlier to the members. So can we see what the CDU, the union, wants to put forward? And the question will be to one of the, or two of our invited experts. Thank you very much, Chairman, ladies and gentlemen, and indeed very much to the experts. Many thanks to the experts for coming to Berlin and really enriching this debate, which is very useful in terms of bearing in mind what's happening in the UK. I have one question each to two of our experts. One to Mr. Aldrich. Now, the public discussion about these Snowden revelations in the UK, as far as we can say from here, reading the press, compared to what happened in Germany, was rather reserved. The extent of surveillance was also taken, it was not questioned by the IPT or by the ISC in Parliament. Now, therefore, my question would be, could you echo again the public debate around this Snowden revelations, and also can you tell us how is the general, what are the general sentiments against or towards surveillance by the intelligence services since 2013, and also when it comes to Snowden? You know, some say he was a traitor, clearly, because he was giving away classified information. Others are saying he was a hero.
What is the predominant position there in the public in the UK? That would be interesting for me. Now, for Mr. Anderson, next question also that refers to what you have said before. The Home Secretary at the time and current Prime Minister Theresa May said bulk surveillance is important to create a haystack in which you then can find a needle in that haystack. Most data are not being looked at, she says. So am I right to assume that in the UK any mass surveillance or bulk surveillance is taking place? So actively looking for a potential needle in the haystack. So you're just using selectors and you're not actually looking at all of the data and do targeted searches, if you will, for individual persons. And does that justify that bulk collection because you want to identify those suspects in that big haystack? So could you talk about that debate ongoing in the UK? Thank you very much. Okay, thank you. Any other questions from the committee? I'm first collecting, in the first round, we're collecting questions from the different political groups. Ms. Reiner. Thank you very much, Chairman. I have a question that also goes to Mr. Anderson and to Ms. Carlo. What can you say, what do you know about specific joint operations in signals intelligence between the British services and the German BND, or our domestic intelligence, which is the Federal Agency for the Constitutional Protection? Now, any bilateral investigations going on names that are also part of the Snowden documents? Now, I also will include the fact that some bilateral collaboration, whatever you call them, also have a trilateral share. In other words, is the NSA possibly also involved in those bilateral German-British operations? Thank you. Thank you very much, Mr. Friesek. Thank you, Chairman. My question also goes to Professor Aldridge and Mr. Anderson. Now, how in the UK should we understand the responsibilities in the area of intelligence cooperation, in the sense that how can intelligence services assume powers if they want to cooperate with third parties? Are there agreements and contracts between the different intelligence services, internationally that is? And is there any oversight, is there any control of those bilateral intelligence cooperation agreements? And if so, who keeps track of the rightful and lawful implementation of those agreements? So maybe you want to say something, or can say something about that. And then also, going forward, do you see, based on your own experience, the experience that you have had and continue to have here in the United Kingdom, and because you also know what's happening with the Five Eyes, etc. In other words, do you see a realistic chance, a realistic opportunity that in the future we will arrive at standards when we talk to cooperating with partners? What standards could be used in the question of intelligence work, surveillance, how you deal with one another, how you deal with your partner? Should that be followed by standards and rigid rules? Or, conversely, will in the future be, again, will we see the principle everyone's fighting against everyone and you're just getting whatever you can get your hands on? Okay, and then we move over with Mr. von Notz, the Green Party political group. Thank you very much to all the experts. Now, when Mr. Anderson, Mr. Anderson said, I'd like to briefly comment. I have full respect of the history of British democracy. Of course I do. However, in view of what you have said, that it's really nice guys working in the intelligence services and they're actually developing computer games. Well, I think it needs more of a critical view on history, I think, and bearing in mind also the history of this country with Nazi Germany and East Germany, we pretty much also see the need for critical control and oversight of any government activities. But that's a proviso. My specific question is this, and it goes to Mr. Jaffey. Now, say, in Europe or here in Germany, anybody, no matter who, journalists, politicians, the justice system, parliaments, regular citizens, any corporation will communicate, and their communication is going through the TAT-14, the big cables, right? Underwater cables. Who legally must not be intercepted? Now, according to British law, whose data may not be intercepted and checked on? Are you recording just everyone? Or are there any exceptions, any groups that are protected from this wiretapping or interception? So that's one. And then there's one question that I'd like to address to all the four of you, and you decide for yourselves who's going to take it. We often have talked about metadata and the way how metadata are collected in the United Kingdom. So could you say maybe a word or two on this actual technology of metadata collection, what that is about? And since people talk about mass surveillance, now, what does mass refer to? What's the amount? What's the actual order of magnitude of data that are recorded, gathered, intercepted every day in terms of metadata? And what is then going to happen to them? So just we want to get an idea of what we're talking about, the order of magnitude. Okay, thank you very much. Before we come to the answering round, I have to ask those four questions, in terms of the last question that has been asked by Mr. Nott. So which of you would be willing and ready to answer? One out of you four. It's like in school. Who volunteers to answer that question? Okay. All right, we'll do that. Ms. Carlo was a little faster, right? Mr. Anderson, next time you will answer, if in case we're asking an open question. But now, as we answer the question, we are going to start in reverse order. Mr. Jaffey, Ms. Carlo, Mr. Anderson, and then Mr. Aldrich. And there was one question from Mr. Jaffey from Mr. von Notz, which was the first question of his. So please, Mr. Jaffey, you have the floor first. Thank you.
Thank you. To give an example of a need for a critical approach, it is inevitable that if any public body is given powers, occasionally those powers will be abused, and that applies to the police, it applies to the civil service, and it also applies to the intelligence agency. There have been recent examples of abuse of powers in the United Kingdom. One example is the case which I mentioned of Belhaj, where two families were suing the security and intelligence services, and nevertheless some of their legally privileged information was collected. There have also been cases in the United Kingdom of what is often called love intelligence, where officers of the security and intelligence services have conducted searches on their family members or their partners to find out what they're up to. That's why strong safeguards are, of course, needed, even if it's decided that the powers are necessary. As for who may be intercepted, there are no absolute exceptions in United Kingdom law as to who may be intercepted. So, for example, I dealt with one case involving two Green members of Parliament, and the Investigatory Powers Tribunal decided in that case there was no absolute prohibition on the interception of communications of members of the United Kingdom Parliament. And in relation to lawyers, there is also no absolute bar on the interception of communication of lawyers, although in both cases there are additional procedures that have to be followed before a decision is taken to intercept those categories. So for members of Parliament, the Prime Minister has to personally give her authorisation, and for lawyers, there are some additional requirements in the new legislation. In particular, interception is usually limited to national security cases, and it has to be, quote, exceptional, unquote.
Ganz herzlichen Dank.
Many thanks indeed. I have two questions. There were two questions to Ms. Carlo. The last one that has been awarded to you, if you will. And then also the second question from Ms. Renner also was addressed to you. Ms. Carlo, please, you have the floor.
Thank you. Firstly, I hope not to disappoint on the first question that I was asked, but I'd simply say, unfortunately, I don't think I'm qualified to answer it. I would only know as much as, of course, is in the public domain on that question. But I would like to turn to the last questions that were asked, if I may, to give more description to what is metadata collection, firstly. Metadata, which is now called communications data in our Investigatory Powers Act, is extremely comprehensive data, particularly in combination, about everything we do, and increasingly has the potential to actually reveal everything that we think. Because communications data is now moving into our internet logs. So in the Investigatory Powers Act, there is a new power for the police to gain access to our internet connection records, and records of everything that we do online and when our devices connect to the internet and what they connect to and when and where we are when we connect to the internet is going to be stored in bulk and accessible to the police. So the metadata is now what websites we visit and when. Obviously, it is the who we email, who we call, who we text, and when, and for how long. It also includes fields of data such as our names, our physical addresses, billing data, location data, usernames and passwords, and so on. So clearly, in combination, metadata can provide an extremely revealing and detailed record of everything a person does. There is now also in the Investigatory Powers Act, and I expect in other intelligence agencies are gaining the same data, secondary data, which is another type of metadata or communications data. Some of this is content-derived metadata, which means that communications data can be pulled out of the content of your communications. So any information about other email addresses and phone numbers or locations can be pulled out of phone calls and emails and stored as metadata as well. So you might see the content of your email as being distinct from mass metadata collection, but actually a large portion of it may very well qualify as communications data or secondary data, these metadata categories. I think also we will see increasingly attempts to collect, attempts to define new forms of metadata, which may be other identifiers. I think perhaps facial recognition and voice prints may very well qualify, and I think in the Investigatory Powers Act, voice print would qualify as metadata. I hope that answers your question.
Okay, wenn ich richtig aufgepasst habe.
Thank you very much.
I apologize. I didn't answer the question about mass surveillance, which is the second part of the question that you asked. I do apologize. We do still use the terminology of mass surveillance, and there's no reason to go around it or try to describe it in a nicer or friendlier way. When Snowden made his revelations, GCHQ was intercepting upwards of 50 billion communications a day. The Investigatory Powers Act is extremely enabling. It's difficult to conceive of more enabling legislation in terms of the volume of material that can be intercepted and collected. I believe that some of the reasons that are given for avoiding pronouncing this as mass surveillance is simply due to the practical limitations of human attention to the data that is collected. That's not how definitions work. We will not avoid calling this mass surveillance simply because GCHQ doesn't have the human resources to look at every piece of information. The fact is that vast quantities of material are being collected and stored. We have no information and no oversight over the profiling and processing of that information, which is inherent in the risks that and the concerns that exist about mass surveillance, of course. And just because there are a limited number of human beings that can give attention to that information, that does not allay our concerns about the constant and ongoing pervasive computerized attention that all of that data is receiving. And that's why we call it mass surveillance.
Okay, herzlichen Dank. Es bietet sich an, jetzt.
Thank you very much. It makes sense, obviously, to pass on that question to Mr. Anderson. I've seen 3 questions that have been put to you. One was Mr. Wendt, Ms. Wenner, and Mr. Friesek. You have the floor, please.
Mr. Wendt, you asked about haystacks. The bigger the haystack, the easier to find the needle. If you don't believe me, I recommend the work of David Wells, a former intelligence officer. He's on Twitter. He has a blog. Take the analogy of Google. Some of us remember the early days of Google. There was not very much on the internet. You would search for something, maybe you'd find it, maybe you wouldn't. Now everything is on the internet. You formulate your search, the answer comes up always on the first page, usually in the first result. That's an example of what I mean. 2 practical instances of how bulk collection, or if you like, mass surveillance, produces results. There's a murder. We know where the person was killed. We know where the body was dumped. But we have no human witnesses and no forensic witnesses. But we have a digital witness. The authorities can go to the telecoms companies and say, do you have any phones that were in this place at this time and at that place 3 hours later? Maybe the answer is, well, there are 2 phones or 3 phones in that category. It gives them the lead they need to investigate. Another example, the true example that's in my report, we had intelligence that an Al-Qaeda plot directed from Afghanistan was instructing its operatives in Europe to communicate in a particular way with each other. Now, this is where you need all the data. You're not listening to everything. You're not reading everything. You are conducting pattern analysis to see if you can find a group of telephones communicating with each other in that very specific way. When you have found that, you have found your cell, and there would be really no other way of doing it. And that pattern analysis is particularly important in cyber defense. There are foreign states, I don't need to say which ones they are, that are constantly mounting cyber attacks. I believe even the Bundestag was a victim of one of these cyber attacks. It is by pattern analysis of communications data viewed in bulk that you can defend against this problem. And believe me, if we're not doing it, our enemies will be. Mrs. Renner and Mr. Fisek asked about intelligence cooperation. I repeat, as I said in opening, intelligence cooperation is vital. We shouldn't see it as sinister. We should see it as something that is necessary in circumstances where criminals don't respect borders. We can't afford to respect them either. But I would entirely echo what Mr. Jaffey said about the need for strong safeguards. And I would say that, because I think it was suggested otherwise, that although the safeguards may not be strong enough for everybody, our new act does require the Secretary of State to be satisfied that equivalent handling arrangements are in place before sharing UK material with an overseas authority, and that that is liable to be overseen by the senior judge who will run the Investigatory Powers Commission. Should we have an international agreement governing this? Well, I think it would be very ambitious, but may I suggest 2 avenues which I think are good. First, we do have, in a sense, in Europe, an international code setting out the ground rules. It's called the European Convention on Human Rights. Secondly, there is an agreement between the UK and the US, currently before the American Congress, but which I hope other friendly states will soon be invited to join, in which a warrant duly authorized in one country will be accepted by law enforcement in the other country as equivalent to one of their own. In circumstances where people now communicate more and more over the internet through companies based in the US and no longer through telecoms companies based in Europe, I think that is a very important development for all of us. And it's also a reminder that although we're hearing a lot today about how new technology is creating more data, which of course is true, if you look at it from the law enforcement point of view or the intelligence point of view, they also feel vulnerable. They see a world where everything is encrypted, everything is moving to internet-based platforms in the US. Their measures can be avoided by such simple methods as using a virtual private network. So it's one of those debates where both sides feels on the defensive. May I say one final word, because the correct point was made that we must take a critical view of history. I entirely agree with that, and I think the United Kingdom and Germany have much to teach each other about that. But the general point I would make is that we should not neglect useful powers properly safeguarded if they can keep us safe. And one reason for that is because you have to look at the alternatives. Now, I understand that these powers do intrude to some extent, at least technically, on the privacy of people's data. That happens when the algorithm identifies my data as something that the machine needs to look at. But if we do not have effective intelligence, we have attacks. If we have attacks, as we see across the River Rhine, we are liable to have states of emergency. We can have warrantless searches, house arrests, curfews. These are not things that any of us want to see. In this area, there are choices to be made, political choices. And that's why, although I'm critical of some elements of our new act, I think it strikes the balance on the whole in a very satisfactory way.
Ganz herzlichen Dank. Ich glaube, das hat viele Fragen in einem Zusammenhang
Thank you very much indeed. This has answered, I think, quite a number of questions in one go. Now with that, I think we'll move over to two questions now, one from Mr. Wendt and one from Mr. Frizek, and those go to Mr. Aldrich.
Thank you. If I can address the first question, which was about the texture of the debate in the UK following the Snowden revelations. There's a famous British member of Parliament called Chris Mullin, who's taken a great interest in civil liberties and human rights. And he records in his diary that every one of his constituents would be happy for every terrorist suspect to be boiled in oil on the word of a single policeman. And that just, he's trying to capture some of the popular sentiment. I think in the UK, a lot of the popular sentiment was rather different to Germany. There is, I think a significant proportion of people in the UK who are comfortable with surveillance, or might even ask for more surveillance. And I'd perhaps make a distinction between mass opinion and what we might call the chattering classes, people who read broadsheet newspapers. At that level, there was an animated debate in which a number of constituencies of both left and right expressed concern about surveillance. I think it's also fair to say that the most recent research on this, supported by the Economic and Social Research Council, indicates a lot of confusion. The answers to these questions depend very much on how they're framed, and people are quite confused about the technology. I was asked whether Snowden was a hero or a traitor. I would say some of this confusion reflects the fact that it's actually quite difficult to have an informed and meaningful debate about our civil liberties, about our privacy, without giving away at least some information which assists our enemies. And in that sense, the judgment on Snowden is always going to be mixed and ambiguous. The second question I was asked was about intelligence sharing agreements. I would say, by my count, the UK has something like 180 agreements bilateral with other states, and it's actually quite difficult on a day-to-day basis to maintain oversight over the sheer volume of information that's being exchanged and the range of different partners that it's being exchanged with. I've spoken to intelligence officers who expressed anxiety about exchanging information with one African domestic security service. They asked to see the text of the agreement with that country. The text of that agreement could not be found, and that seemed to underline their anxiety about that exchange of information. I think the upside of that story is the work that's been done by the Venice Commission supporting the Council of Europe and their keenness to extend the provisions of the European Convention not just to its signatories but to other countries that they're collaborating with regardless of jurisdiction. And I think that's particularly important.
Ganz herzlichen Dank.
Thank you very much indeed. And now let us move over to the second round of questions. And I think it's my colleague, Mr. Szypanski, who's going to be first, and then Ms. Mittag, Ms. Renner, and Mr. Ströbele.
Thank you, Chair. One question to Mr. Anderson, please. Of course, one remark I'd like to make. Of course, we make a distinction here between mass surveillance and mass collection in Germany too. And I can only confirm, basically, and subscribe to what you said earlier. At the end of October, the German Bundestag adopted a bill regulating and protecting telecommunication of European citizens and protects telecommunication from any activities of our own foreign intelligence service. There's one thing I'd like to know. What is important for us here is your view on the surveillance of external communications. That is to say, what the British services cover here in Germany. And I would like to know whether there are any plans for changes underway, whether any changes have already been implemented, maybe, when it comes to surveilling foreign citizens. And what is the current status of the discussion in the UK on this issue? Like I said, we made a decision here in our parliament in October. Is there a similar discussion in the UK? Well, those were two questions, right, to Mr. Anderson? Okay, thank you. Great, Ms. Mittag. Well, one question to Mr. Aldrich, one question to Mr. Anderson. Mr. Aldrich, you spoke about better ways to protect whistleblowers. You said this was important because they have an important function. Here in this committee, we deal with various opportunities that different intelligence services have in the countries throughout the world. But there's one thing that comes to mind. Is there a way that findings gathered by intelligence services could be published by whistleblowers to fulfill a certain purpose? This, of course, would kind of discredit the true whistleblower in a way. But things that are going on in the intelligence services, can you really rule out that those findings are also published through the whistleblower avenue, if a whistleblower comes out anonymously, for example, without others being able to retrack where they got the information from? My second question to Mr. Anderson, you spoke about the new bill in the UK. What about the Brexit discussion? Does this not have an impact on this? If their references are made to European courts, certain agreements have already been made between, or have already been cancelled between Europe and the UK last year, and so does this not have an impact, because protection might actually be limited to UK citizens? And what about UK citizens? I'm not speaking about UK citizens when they come to visit here, but it is only limited to UK citizens and not European citizens in the UK, let alone outside the UK. So this problem is not solved by this bill, and we already heard that the protection of citizens in the UK was relatively minor compared to other countries, compared to Germany, for example. Well, we know that UK citizens enjoyed less protection than citizens of other countries. So, what I'm saying, as far as the protection of EU citizens or German citizens in the UK, would they be protected in a better way by the new bill, or is there any improvement at all? Well, that was quite a comprehensive and lengthy question. Ms. Renner.
Ja, ich bitte da die Sachverständigen auch zu entscheiden, wer
Yes, I leave it to you who wants to answer this question, because my question is of a somewhat general nature, refers to the cooperation of intelligence services. The swapping of data, if you will, is a key element of their activities. And right here, we not just look at what metadata are exchanged through common databases, but we also look at how relevant it is for the UK intelligence services that data can be swapped, data that you cannot gather in your own country, on your own. The services call it like complementary SIGINT surveillance or something. We call it a ring exchange here. So, data gathered on the internet. Are you aware of such an exchange mechanism among the intelligence services, that you basically ask someone else to gather the data that you're not allowed to gather? That was my first question. And my second question, Mr. Jaffey. In this committee, we not just deal with mass surveillance, but we also focus on the selectors, and as such we look at illegal espionage or politically questionable espionage against German or European interests. And I would like to know, do you have any knowledge that UK services spy on governments, parliaments, journalists, international aid organizations? And are there any ways for those affected to defend themselves against such espionage? Do they have the right to seek information? Do they have the right to demand their data be deleted? Do such avenues exist? Thank you. Thanks, Ms. Renner. Last one, Mr. Ströbele for the Green Party.
Ja, danke. Ich begrüße Sie auch.
Well, thank you and welcome again. I do have one question that I'd like to direct at Mr. Aldrich. And, well, I don't know who's better qualified to answer, because I came in a little late, so I'm not sure, but you can decide. Okay. My question is the following. The UK is mentioned in the Snowden revelations time and again, but there are two areas where the UK is mentioned. One being tempora, and everything related to tempora. And the second is the gathering of data in telecom fiberglass cables in the south of England, apparently cables routed from Europe to the US through the south of England. So data that is tapped from that cable. This is where the UK is mentioned frequently in the revelations. So my question is the following. Those two factors, were they part of a discussion in the UK, or are they still part of a discussion in the UK? Were there any positions taken by the intelligence services? Was this important in any way? And if so, what did that information look like? Did people know what tempora was? Was it part of a public discussion at all? And if so, in what respect? And was there an admission? Did the intelligence services admit that UK services actually had access to these fiber cables, or did they say that they have no access to that? So I'd just like to know what the status of this discussion is, and maybe I give you a little bit of background information as to why I'm asking this question. Here in our country, people still have the impression that our intelligence services don't even know what tempora is. They say they have no idea, never heard of it, and were never aware that information was tapped from those fiber cables in the south of England. The first thing they hear, that's what they claim time and again. And this is why I asked this question. Is there any discussion about this in the UK? And if so, what is the character of this discussion? Thank you. And again, we start answering the questions in the alphabetical order. Ms. Aldrich, I think there was a question by Mr. Schröbele and Ms. Mittag. Yeah. Okay. No?
Okay.
Good. All right. Sorry. Mr. Aldrich, please.
Thank you for your questions. I think the first question I'd like to address is the question of whistleblowers and whistleblower protection. And I think getting the legislation around whistleblowers right is extremely important. I've interviewed many whistleblowers, and they will often say, we've paid a very high price for our revelations. This is not just in the area of intelligence. It might be about whistleblowing on abuses in the health services, in a whole range of areas. Whistleblowers will say to you, the journalists we collaborated with have won their Pulitzer Prizes. The lawyers we collaborated with have conducted their high-profile cases and gone on to be High Court judges. But we've been punished. We're sitting in exile. We've lost our pensions. We've lost our jobs. It's very difficult for whistleblowers to bring abuses to attention to public notice without suffering. It's also, in the national security realm, it's difficult for whistleblowers to bring intelligence information forward without simultaneously damaging national security. And I think the Snowden revelations have genuinely been mixed in that regard. So finding a way to, finding the right receiver for the information from whistleblowers, potentially inspector generals, perhaps some other avenue is important. It's important that we actually have someone actively trying to contact whistleblowers. If whistleblowers have to come forward themselves, even within an organization, they potentially damage their career. I think once the information is brought forward, it's actually not difficult to triangulate it. It's not difficult to validate it for a whole range of reasons I could explain. And I think it's also important to change the culture within intelligence services in terms of better education. The United States has received a lot of criticism in terms of its intelligence activities, but one of the things it does very well is it allows its former officials to publish memoirs. And you know, those memoirs are very widely read, and the American public, for good or ill, are much better informed, much better educated about intelligence than perhaps European populations. And that allows them to have a more meaningful debate about intelligence. I was asked a question about tempora, prism, these sorts of systems. I don't think the public understanding of these systems is particularly good in any country, but I think one of the most common misunderstandings is they're often seen as a system owned by a single country or a single agency. And this misperception also extends to intelligence exchange. I would argue that our view of intelligence exchange and collaboration on these systems is very outdated. As early as 1970, the UK's intelligence agency, GCHQ, moved from being an organisation which simply swapped intelligence with the NSA to one which did joint operations. To some extent, GCHQ became part of the NSA. And this makes debate over these systems and exchange and who owns them difficult to unpick. I'd also argue that although the understanding of these systems is not very widespread, actually you could have read about this before the Snowden revelations. Anybody reading Wired magazine or Register or some of the more technical publications in 2009 or 2010 would have had a pretty good idea of what these systems were doing and capable of even before the Snowden revelations.
Ganz herzlichen Dank. Jetzt muss ich mal schauen,
Thank you
ob ich das richtig sehe.
very much. I
Da
think
habe ich
our
Anderson
Next expert is Mr. Anderson, question by Mr. Szypanski, and a question by Ms. Renner. That was kind of an open question directed at anybody, and that would, in this round, also go to Mr. Anderson, because Ms. Carlo had her chance earlier. And, of course, a question by Ms. Mittag as well.
Thank you. Well, both Mr. Szypanski and Frau Mittag asked about surveillance of external communications. So far as I know, all countries have more relaxed rules in relation to surveillance outside their borders, particularly of non-citizens, than they do of surveillance inside. I take as my example the United States, which is often given credit for relaxing at least one of its powers of bulk collection, albeit not a power that was very much used. But outside its frontiers, it operates pursuant to an executive order 12333, the breadth of which is evident from the fact that there is one specific exclusion in that order from the powers that may be used, and that exclusion is for assassination. The Privacy and Civil Liberties Oversight Board in the US is looking at that, has been doing for 18 months, but really, if you're a non-US citizen outside the US, nobody really knows what protections you have. Can I say two things about UK law? The first is that citizenship plays no part in our law at all. That's not just the new law of this week, it's also the old law of 2000 and perhaps even the law of 1985 that preceded that. All that matters to us is, are you inside the United Kingdom or are you outside? And there is, in other words, when I'm here, I'm in exactly the same position as you. When you are our guests in London, well, you're in exactly the same position as I am. And the reason for that is because it is assumed that there are other ways of finding out about you when you're inside the borders, but there may not be when you are outside, so a more relaxed regime is appropriate. And the other point I would make about the UK law is that everything that happens, even outside the UK, must be the subject of a proper warrant or authorization signed off by the appropriate people. Now, that is very reassuring if one is looking at a warrant, say, to tap a particular telephone in Germany. Where it is perhaps less reassuring is if you are looking at the exercise of one of these bulk powers, where you would indeed need to have it warranted in the first place, but there would then be less stringent controls on how access is managed to that bulk material. So what if the intelligence officer, to take Mr. Jaffey's example, had a girlfriend in Germany, he wanted to know what she'd been writing in her emails, would there be a vulnerability there? And all I could say about that is, well, first, there are very rigorous internal controls in the agencies, and secondly, there is rigorous and increasingly rigorous external review led by judges but with large technical staff, which has uncovered precisely the examples that Mr. Jaffey was talking about. Ms. Mittag also asked about the impact of Brexit. Well, fortunately, Brexit does not apply to the European Convention of Human Rights. That's the first point. We will remain subject to that court and to the right of individual petition to that court. The other point I'd make about that is that, in a way, it's a bit like a divorce when there are children, and we may try to leave, but you can't really ever completely leave the marriage because you've also got so many other things to talk about. And if we in Britain want to continue to have access to European data, be that passenger name records, be that financial data, you, I'm sure, will only allow us to have it if you can be satisfied that our standards of data protection are good enough. Very much as we all collectively take that position now with the Americans and with the Canadians and with others. You're familiar, I'm sure, with the case of Schrems, which is an example of that. So perhaps it's like the Hotel California. We'll check out, but never really leave.
Sehr schön. dass Sie uns diese Textpassage noch einmal in Erinnerung gebracht haben.
Thank you for reminding us that, for bringing that back to memory. I have no question to you, ma'am, I think, in this round. So, sorry, Mr. Schöble can't be heard. He's not using the microphone.
Ich hatte
No, I
Frage gestellt,
asked a question
einem Sachverständigen beantwortet worden.
which was answered by one expert, but I'm still waiting for a second answer. And maybe you can decide, Ms. Carlo, or who wants to answer this question. Ms. Carlo, would you like to answer Mr. Strible's question? Or Mr. Jaffey? Take your pick.
Wer möchte? Herr Jaffey, Sie zusammen oder Frau Carlo?
Together?
I'm happy to answer.
Okay, in der nächsten Runde ist dann Frau Carlo aber dran.
Okay, next round goes to Ms. Carlo then.
Dann die beiden aufgeworfenen Fragen. Ich hatte sie nämlich auch noch von Frau Renner notiert.
Ms. Renner, I think, also had a question to you.
Fragen von Herrn Kollege Ströbel und Frau Renner.
Okay, Ms. Renner, Mr. Ströbel's question, please.
Dealing with Frau Renner's question first, is there any information that's been published that the UK security and intelligence services have targeted foreign governments, parliaments or aid agencies? In relation to foreign governments or parliaments, I only know what's in the Snowden documents, which suggest that espionage takes place. I'm sure every country with a developed security intelligence services conducts quite aggressive espionage against other states, including friendly states. In relation to aid organisations, some information has come out of United Kingdom litigation, and two non-governmental organisations, Amnesty International, which needs no introduction, and the South African Legal Resources Centre, which is probably the equivalent of Liberty or the American Civil Liberties Union in South Africa, were both subject to interception by GCHQ, and the UK tribunal found that that interception had been unlawful. Very little information about what had taken place, why it had taken place, and why it's unlawful is in the tribunal's decision. Most of the reasons were kept secret, but nonetheless the tribunal did find that Amnesty International and the Legal Resources Centre had been subject to interception, and the interception was, in the particular circumstances of those cases, unlawful. So it does go on. Herr Ströbel's question about tempora. The current public position of the United Kingdom government is that, first of all, they accept that they do carry out collection of data from fibre optic cables. That's admitted. They don't say how much they collect. That is kept secret. They do say that, in principle, collecting very large quantities of data is lawful, and the current legal position in the United Kingdom is the tribunal has agreed that, in principle, it is legal to collect large quantities of information. That decision is currently pending before the European Court of Human Rights. And as Mr. Anderson said, the warrants that are granted for that activity are general, so there is no need for specific approval of each selector where selectors are approved. The Home Secretary or the Foreign Secretary's job is to approve the warrant, and the selectors are a matter for the Security and Intelligence Services.
Okay, ganz herzlichen Dank. Ich muss jetzt mal in die Runde schauen.
Thank you very much. Mr. Anderson, you need to leave, right? Is that right?
Yeah, have you got a few?
You got 5 more minutes?
Have you got questions?
Yeah.
Entschuldigung. Dort sind keine Fragen mehr. Ich glaube, eine Frage ist nämlich noch bei der Union in der nächsten Runde. Vielleicht schaffen wir die noch.
Because there's one more question. 2 more questions? Yes? Can we take those?
Mittag hat sich noch mal gemeldet.
Okay, Mr. Wendt, Ms. Mittag.
Ja, Kollege Wendt.
Chairman, I must leave in 5 minutes.
Yeah. We try to have precise questions and precise answers from you, right? Okay, thank you.
Nur nochmal, also vielen Dank, wir sind, glaube ich, Brüder im Geiste, was auch Ihre Heuhaufen-Theorie angeht.
Brothers in spirit, I think, also as far as your haystack theory is concerned.
in einem Bericht,
in a
der viel
report
beachtet wurde vom Juni 2015, im sogenannten Bericht A Question of
June
Trust,
2015, a question
eine
of
Reihe von Änderungen
trust.
rechtlicher Rahmenbedingungen für die britischen Nachrichtendienste
Suggested a
vorgeschlagen.
number of
Können Sie vielleicht
changes
noch mal kurz
for the
die
British intelligence
wesentlichen
services.
Aspekte erläutern,
Could you
die Sie
maybe
vorgeschlagen hatten, und was wurde dann auch wirklich
reiterate the main
umgesetzt?
aspects, the main items that you suggested, and also
Vielen
tell
Dank
us
für
what
Ihre
has been implemented? And thanks for being with us.
Mittag hatte ich noch.
Ms. Mittag?
An Herrn Anderson noch
Yeah,
ergänzen.
also a question to Mr. Anderson.
Wie zählt denn in Großbritannien
When we
Glasfaser,
look
was
at
England
the
verlässt,
UK,
kurz vor der Küste
what
ankommt,
is,
beziehungsweise Satellitenverbindungen? Sind das denn Verbindungen?
if we think of fiber cables, would a satellite, for example, be considered a UK thing, because or not, because it's outside of the UK, so to speak? Okay, Mr. Anderson, please.
Well, thank you. On my report, A Question of Trust, I'm afraid I made 125 recommendations, including one that I wrote in a secret letter to the Prime Minister because I wasn't allowed to publish it. More than 90% of those were implemented. I think the most important ones, apart from the transparency, which Mr. Jaffey was achieving at the same time in the courts with the help of Mr. Snowden, was the introduction of judicial authorization for warrants, or judicial approval for all warrants to intercept content, and the creation of a much bigger and more powerful and, I hope, more professional intelligence regulator. Not everything was adopted. I think one big issue, which, as we have mentioned, will need to be decided by the European Court, is whether we have yet done enough to ensure prior independent authorization of all requests for metadata. We have it for some, but not for all. It seems obviously a good idea, but sometimes ideas collide with the facts. And it's not to say that this would be impossible, but I cite an example in my report of a kidnap which turned into a missing persons investigation, which turned into a murder inquiry. It lasted 9 weeks. I think in that period, 600 different requests for metadata needed to be made, sometimes very urgently and at short notice. Now, that's not to say it couldn't be done, but certainly one would not want to be going across to a court and asking a judge every time one needed to take a decision like that in a fast-moving investigation. Then the other question, I'm so sorry, I can't read my own writing. Could you just remind me of the question?
Well, if you think of satellite communication and glass fiber, would the theory, the UK theory, apply?
I'm going to have to ask Mr. Jaffey, because I don't know the answer to that. There is currently a different regime under UK law governing satellite communications. What I'm quite sure about, when I think about it, is that it would be subject to the same general regime, in that if you were going to try to intercept such a communication, and I don't know how feasible that would be, one would need a warrant in order to do it. That would need to be signed off by the senior minister in the government, and it would also need to be signed off by a judge. But I'm afraid I'm not the person to ask about the technicalities of that.
Okay, ganz herzlichen Dank. Weil Sie weg müssen,
thank you.
Sie jetzt verabschieden.
Thank you, Mr. Anderson. And thank you for being with us. Mr. Anderson, it helped a lot. We found many answers to many questions. There's still a couple of questions open, but you helped us a lot. Thanks for being with us and answering all our questions. Safe travels. Thank you. All right, let's move on. All right, who has another question? Dr. Hahn?
Herr Kollege Hahn, wenn Sie wollen.
Dr. Hahn, please. I can't hear Mr. Schröbel.
Vielleicht kann der Sachverständige, der gerade angesprochen worden ist, dass die Frage, die hat mich jetzt auch interessiert.
Mr. Jaffey, because I was interested in that question as well. The question Mr. Anderson wasn't able to answer. Maybe Mr. Jaffey can be given the chance to answer that question. Can you? Would you? All right.
Dann nehmen wir das noch mit.
Thank you. All right. Let's do this and then we move on to Dr. Hahn's question. Good.
The answer is that in order to intercept satellite communications, a warrant is required. It's a general warrant, so it doesn't require any specification of selectors or any detail. It just authorizes the entire operation. If the person who is subject to the operation is present in the United Kingdom, they get the protection of the right to privacy in Article 8 of the European Convention on Human Rights. If the person who's subject to the operation is outside of the United Kingdom, for example, in Germany or Afghanistan or wherever, then the current status of UK law is that Article 8 of the Convention does not apply. So it depends where you are in terms of the quality of protection. But there is still a piece of paper that's signed by the Foreign Secretary that says, I authorize this operation to take place in relation to this satellite.
Okay, ganz herzlichen Dank. Jetzt kommen wir zu
Thank
den
you so
Fragen
much.
des Kollegen Hahn.
Dr. Hahn,
Und
please.
vielleicht die Sachverständigen die Mikros noch etwas näher zu sich ranzuziehen.
And maybe the experts could move the microphones a little closer. Thank you.
Vielen Dank, Herr Vorsitzender.
Thank you, Chair.
Fragen. Sie haben
I have
vorhin
two
gebeten, dass wir die
questions.
möglichst konkret
You asked us, please, to put the questions very concretely, but the problem is that we don't know exactly what the experts know and who would be able to answer our questions. So I would like to ask two questions, and I'd be happy if anybody felt able to answer them, to please do so. First question, it's on cooperation between British and German secret services. The British government is not very free with the information it provides us with, to say it mildly. Even it's been threatened that cooperation would be interrupted if anything ever became public. So my question, generally speaking, is what kind of larger cooperations have you had over the past 15 years or the time period we're talking about? What do you know about operations between, joint operations between the British and German secret services, and in which areas? And the second question, sometimes here in the committee, and sometimes also the German government asked the question whether the Snowden documents are actually true, because nobody's ever seen any originals. It was just told us via the media. Maybe all this isn't true. So do you have any knowledge about this, you, from your activities? Do you know whether or not there are any kind of falsifications amongst these documents, things which were completely untrue, or do you believe that all Snowden documents are real and true, based on your knowledge? Thank you very much. I'll try to make this a bit clearer before we continue with the questions. Who'd like to answer this question?
Aldrich?
Mr. Aldrich.
Beide?
Both questions?
Das war ja eigentlich eine Frage an zwei, so
well,
habe ich es verstanden.
Actually, it was one question, I think, no, one question, but for two experts.
Sonst macht's Herr Aldrich.
Anybody else, or just Mr. Aldrich?
Okay, macht beide Fragen, Herr Aldrich.
Okay,
machen wir das als zwei Fragen.
Mr. Aldrich, then we'll count it as two questions. Colleague Wendner.
Vielen Dank. Ich hätte eine Frage an den
I have a
zwei Fragen an
question,
Herrn Aldrich.
two questions for Mr. Aldrich.
Zum einen, Sie hatten vorher diesen Bereich angesprochen.
Firstly, you talked about this area of delimitation of where whistleblowing begins, where giving away secrets ends, and, you know, this area. So is there anything, it's a political question, of course, what would be the good part and where does the bad part begin, and where are the delimitations? Could you give us an example, maybe? What do you do in the UK? Or how do you want to have regulation maybe for the future? And then, second question, after Mr. Snowden's revelations, what about the debate in the British government? Were there any kind of activities within the secret services, be it GCHQ or in the Home Secretary's ministry, that you said, okay, we'll have a select committee or inquiry committee or something, that you stopped certain actions? Were people hectical, or was it something quite relaxed, business as usual? Those are my two questions. Thank you very much. Now, the third parliamentary group and the fourth parliamentary group. Anybody? So far, no questions. Maybe we'll have another round of questions then. So, these are the two questions.
An Sie, Herr Aldrich.
Mr. Hahn has asked you, Mr. Aldrich.
Thank you for your questions. Perhaps some of my colleagues might want to come in on some of these questions, because I'm sure they also have contributions to make. On the issue of British-German intelligence cooperation, I would say, first of all, as far as I'm aware, there's been no large-scale exchange of bulk or mass surveillance data. So the cooperation tends to be more specific, and it's focused on counter-terrorism, on cybersecurity, also military operations in Afghanistan and in Iraq. And some of these cooperations have been important in terms of saving lives, and that point was also made by David Anderson. I think on the authenticity of the the Snowden documents, I've spoken to many people about them. So again, it's about good political science triangulation, if you like. The people I've spoken to, some of them in a number of countries, including Britain and the United States, the documents are certainly authentic, but I would make a distinction between the documents and the PowerPoints. So the documents are often rather mundane factual descriptions. They tend to be quite accurate. The PowerPoints are often presentational. They're often one constituency within the intelligence agency trying to persuade or explain themselves, or even perhaps exaggerate their achievements to another constituency. And so the PowerPoint slides are sometimes, they contain hyperbole, they contain boastfulness, and so they should be treated with a little bit more skepticism. I was asked a question about whistleblowers, and I think it's clear that most countries have mechanisms in place to receive whistleblowers. The UK has a number of counsellors, ombudsman, this sort of thing. This doesn't work very well. And so this is why I'm keen on the office of an Inspector General. An Inspector General is rather like an internal affairs investigation in the American police. They're rather more proactive, and it's easier for a serving intelligence officer to go to these people without prejudicing their career. But perhaps my colleagues might have things to add to all those three questions.
Just one point in response to Herr Wendt's question about the effect of the Snowden revelations in the United Kingdom. One of the main effects, I think, has been to reawaken the United Kingdom's oversight mechanisms. So the tribunal, pre-Snowden, had never made a finding against the UK security and intelligence services. It had heard over 1,000 cases before Snowden, but had never found against the security services. It has started doing so now. And also the systems of judicial commissioners who would provide part-time oversight of the security services has become more rigorous and more well-resourced. And the commissioners' reports, which are published every year, are no longer very brief and uninformative. They're now often quite long, and they make significant criticisms of the security and intelligence services and impose requirements for improvements. So there has been some improvement in the quality of oversight.
I might just submit another perspective, if I may, on the potential that there is some hyperbole in some of the PowerPoints revealed by Edward Snowden, which may well be the case, and it's something that I've heard suggested only by people trying to defend GCHQ, actually. But if it is the case, I would be very concerned that it reveals, if not the reality, certainly the ambitions of those within the agencies. And I think that's worth bearing in mind when looking at the documents. Also worth bearing in mind that these are now ancient in terms of technological development, and what's now possible within the agencies may far exceed what we've seen actually in the Snowden documents.
Ganz herzlichen Dank. Ich sehe jetzt noch Fragen bei der Fraktion CDU.
Thank you. I can see questions with the CDU-CSU parliamentary group. Mr. Szymanski. Yes, two questions for Mr. Aldrich. Mr. Aldrich, through Edward Snowden's revelations, British communications have been focused on, and allegedly, possibly, they were spying on German citizens. They might have been spying on German citizens. So I'd be interested in knowing what the legal situation is like, whether a telecommunications service provider is obliged under your law to provide access to telecommunications customers' data, and whether or not there are some back doors. They have been asked to have back doors in their key technology. And I'd like to know what the discussion is like, or whether what the regulations are going to provide for in the future. Colleague Mrs. Mittag. I have a question for Mr. Aldrich and Mr. Jaffey on this fiber telecommunications and the satellites. Now, you said that normally you'd need a warrant. So nowadays, with these connections, you can very often not even find out who is communicating with whom, even within the UK, because it might be working via satellites which are outside the territory of the UK. So what kind of a warrant would that be? Because I found the answer was not very precise. Is there a framework? Is there a kind of that you certainly need to have a certain warranty if you want to have bulk interception of fiber communications or satellite communications? Maybe not bulk, but many data. And we do have findings, and we've read it in the press, that this is done in the UK, and what kind of a warrant is necessary or was necessary under the law now and will be necessary under the new law. Now, we have Mr. von Notz. I have a political question, whether in the British discussion, and I'm asking Mr. Aldrich and Mrs. Carlo, whether in the British debate the question of friendly countries, whatever that might mean. Well, politically speaking, we do have friends. We heard that that's not the case with the secret services, but countries do have friends. So politically speaking, if you have countries being friends, what about British institutions, ministries, politicians? Are they being spied upon, and does that have an impact on the discussion in the UK?
Das Ganze so, wer nicht verschlüsselt, der ist im freien Raum unterwegs oder so, ob es da sozusagen eine politische
you just say, okay, if you're not careful enough, then it's just too bad. Is there kind of discussion about the executive bodies, also on data exchange between these services? What do you hear about that? Thank you, and last but not least, colleague Renner. A question for Mr. Aldrich and Mrs. Carlo. In our inquiry committee, we have the right to see documents and ask the federal government to provide us with documents, and there were some documents there concerning the cooperation with the UK. And at first, before we were allowed to receive them as an inquiry committee, and we're talking about German documents, first the Brits had to be asked for permission. And we realized that the NSA and the USA are very restrictive, but the UK is completely shut down. Even on an operation which was the subject of investigation of the inquiry committee, we were told that we were not even be told the operational name. And we were threatened that then Secret Service cooperation would be stopped. So how come the UK is so restrictive? when we're talking about parliamentary inquiry work in the German Federal Republic. And would the same thing happen if it were about British MPs? Now, before we answer these questions, I'd like to give the floor to a representative of the German federal government, Mr. Wolf. I just wanted to talk about how certain things are being filed. Now, the question was a bit general, and the responses there, the witnesses will have to answer whether or not they will answer, and of course that might be under the British law. We won't be able to judge that because witnesses are free to make their statements. That's what I believe. So now we'll go in the opposite order. Mr. Jaffey, I have Mrs. Mittag's question here.
Yes. In response to Frau Mittag's question, if there is interception of an entire satellite link, she's entirely correct that you don't know in advance who is communicating with who. A satellite link will have a very large number of communications, thousands or potentially hundreds of thousands of communications all mixed up. So the warrant is general in nature, and the warrant authorizes the interception of all of the communications over that satellite link. And so that is very different from a traditional police warrant, which would be, for example, over a particular place, this house, this office, or a particular person, these 5 people who are suspected of being involved in a conspiracy to commit a crime. And so I'm afraid that I can't offer a precise answer because the warrants are deliberately extremely broad. If I could also just mention one point in response to Herr Szypanski's question about providing access. Under UK law, there is a duty on telecoms companies to provide access on request, and they can be and are served with what's called a technical capability notice, requiring them to install equipment or make arrangements to provide access to communications. And that can also include a duty to remove any encryption which they add or provide. Hope that's of assistance.
So, jetzt muss ich mal schauen, weil da auch offene Fragen da waren.
Now we had some more open questions, I think. Colleague Mr. von Notz and colleague Mrs. Renner had put questions to Mrs. Carlo.
Also die beiden an
So those two, Mrs. Carlo.
Thank you. I think if I'm right in interpreting Dr. von Notz's question, it is whether politicians are being spied on and whether that affects the debate. Is that correct?
Well, also da sozusagen Dienste, wie wir gelernt
services,
haben,
as we heard,
auch innerhalb von Europa
even within Europe,
einfach gegenseitig die Bevölkerung
very often
massenhaft erfassen, sind eben
have mass retention of the population's data. Then in the UK we also have politicians, the judiciary, journalists and so on. They will also be affected by mass surveillance, I think. And is there any kind of discussion about that? Also with what you're doing, with regards to what you're doing, or don't you care?
Thank you very much for the clarification. The issue of surveillance of sensitive communications did feature in the debate that we had around the passage of the Investigatory Powers Bill, now the Act. We discovered post-Snowden, through the course of litigation and also the passage of this bill, that the protections that we thought elected politicians had from surveillance weren't actually really concretely there. And certainly their communications are now, as are basically everyone's, fair game for surveillance. There are some very limited protections for members of parliament, but then I would have to say that they're not incredibly meaningful. Legally privileged communications have had some safeguards for surveillance. However, there is a national security carve-out. So if it is deemed in the public interest to surveil someone in the interest of national security, it is possible to monitor their communications with their lawyers. Now, there are arguments, obviously the government has made arguments for that, but it creates an enormous problem for justice in the UK for obvious reasons, and has a chilling effect on people's willingness to talk frankly with their lawyer, and therefore guarantee their access to justice and a fair trial. A really problematic area in the UK, talking of sensitive communications, is the communications of journalists. And we have fought and lobbied very hard for protections for journalists in the UK, and there has been a massive pushback against that from the government. So unfortunately, the end product in the UK is not a model to follow, and the journalists are extremely concerned about it. There is very limited protection for their communications with sources, and the risk that sources will be identified. We've already seen through some oversight reports in the UK that literally hundreds of journalists and the sources have been monitored, and their communications data has been accessed by the police. It's very tempting when the data is there, and this creates a real problem for the free press. So some of the work that Liberty is doing as a human rights organisation, I find it a little bit depressing that we have to do this, but we offer training to journalists in how to protect their communications, how to send and receive encrypted emails, and advice about source protection. So yes, it has featured in our debate, but unfortunately the solutions haven't been necessarily provided in the legislation. I hope that answers that question.
Okay, die Frage von Konstantin von Notz auch.
No, Konstantin von Notz's question, has that been answered? Okay, good, very well. Thank you very much. Now, the full question to Mr. Aldridge, both from Mr. Szymanski, Ms. Mittag, Mr. von Notz, and Ms. Renner. All of them bombarded Mr. Aldridge with questions. Please, you have the floor.
Thank you. It's nice to be bombarded, but I think some of the questions have already been answered very satisfactorily by my colleagues. I'll just try and sing a descant to those. So there was a question about backdoors and the targeting of German citizens. Yes, backdoors are certainly used by the UK services. I think one of the most interesting things here is that the issue of backdoors and cooperation with communications and information providers, has been actively discussed by British and American intelligence services since the 1980s. There's evidence to suggest that from the 1980s there was a concerted campaign by the Five Eyes to address this issue, and we actually think some technology firms aren't what they appear. They're actually owned by the intelligence services and are in effect within the circle of secrecy, if you like. And the culture there is changing. It's very interesting to see that mathematics graduates from my campus 10 years ago, their ambition would be to go to work for GCHQ. Some still have that ambition, but others are burning with zeal to go and work for technology companies and roll out end-to-end encryption. So we're seeing more resistance. This is to some extent generational from some of the ISP providers and communication providers. The question about warrants and satellites, I think, has been answered, but I would say the shift from warrants by the Home Secretary or the Foreign Secretary to judges is an improvement. The numbers of warrants that cabinet ministers had to look at, either fresh warrants or changes to warrants, was so great that it was difficult to see how cabinet ministers could have given these things serious consideration. The question about the targeting of lawyers, journalists, politicians, academics, I think this is a very serious matter. and as has already been suggested, all these people are having to take serious concern over their communications. It is possible to maintain a degree of privacy, but it's time-consuming and laborious. I know people who've written books about intelligence matters. The text of that book was with the authorities before it was even sent to the publisher, because that was typed on a machine that connected to the internet. Someone else who took active security measures typed their book on a laptop that had all the wireless facilities disabled. That book did not come to the attention of the authorities. So it is possible to take appropriate security measures, but they have a cost in terms of time and effort. Finally, the question about access to documents, German documents about Anglo-German intelligence cooperation. I'd firstly say the threats to cease intelligence cooperation are idle. These are often made, they're never carried out, simply because the cost to the two countries in terms of security would be too great. But the fact those threats are made tell us a great deal about the nature of the agreements between states over intelligence cooperation. Those agreements are mostly about the security of information and the ownership of information. In other words, they're very Praetorian in terms of who and how those documents can be shared. Thank you.
Ganz herzlichen Dank. Ich gucke mal in die Runde.
Thank you very much. I'm looking into this round of our colleagues. Currently, I don't see that people want to ask a question. No, my colleague, Ms. Misak, wants to ask one. Yes, indeed, there's one question. And that would go to Mr. Aldrich and Mr. Jaffey. Has the behavior of internet service provider changed, or telecoms companies? No, following the Snowden relations, or following the debate around Snowden, ever since the time also we've instituted this committee of inquiry. And how much is now actually going on, this level of surveillance? Is that limited in time? Is that limited by type of contents? Are they intercepting all data? Are internet service providers aware of the fact that there's a warrant in place and they should now intercept this data, or is it limited in time? Thank you very much. I think we continue with Mr. Jaffey now, if that is okay. Can you take that question?
Of course. It's important to distinguish between a traditional telecommunications company like British Telecom or Deutsche Telekom, who provides internet services, and newer companies such as, for example, Google or Facebook, who provide services over those networks. In the UK, the relationship between traditional telecoms companies and the security services has always been very close indeed, and those companies have always provided a lot of cooperation, often voluntary, but now, more recently, they've insisted on actually seeing warrants. Some documents have been published as a result of claims in the UK, and those documents show that each of the UK telecoms companies have been ordered by the government to set up a separate board of directors who deal with national security issues, who've been security cleared for that purpose, and it means that issues relating to national security can be approved by that small group of people, and they don't have to go to the ordinary board, and they don't have to be made public. The other providers, the newer companies, the Googles and the Facebooks and so on, the degree of cooperation which they provide is still quite large, but it is much more hesitant after Snowden, and my sense is that their relationship with the UK security and intelligence services is more complex, and it will depend on the particular circumstances in which help is requested.
Und Herr Aldrich.
Mr. Aldrich, please.
I agree with all that, and perhaps just to elaborate on the case of Facebook. So these newer companies have I describe it as a civilized relationship with the UK government. There's normally a single point of contact, so that allows a degree of personal confidence to be built up between the person making the requests and the person in Facebook or a similar organization who are receiving those requests. And one of the impacts of the Snowden revelations is that these companies have had to think quite carefully about how they respond, to develop an ethical code and some benchmarks. Typically, Facebook respond positively to about 75% of requests from the single point of contact in the UK government. So if it's a request for information on paedophiles or terrorists, they're likely to look upon that favourably. But there was an instance when the UK asked for information on a demonstration by the English Defence League in Luton, and Facebook said, no, that's actually a political request. Although there are some public order issues there, we don't feel we can comply. So there is a judicious process within Facebook, and the UK government normally respects it. Of course, Facebook are receiving requests from other countries. Another country that I know of that shall be nameless asked Facebook for information. Facebook said no. And so what that country did was go round to the local offices of Facebook and arrest a couple of people and said those people stay in jail until we get the Facebook information we need. So the person handling these requests in Facebook has quite a challenging job, actually.
Okay. Schau noch mal in die Runde.
Okay, thank you very much. I'm trying to look if my colleagues want to ask questions. If that is not the case, we've come to the end of our inquiry. As I said before, we'll be taking minutes here. Now, after the stenographic account is completed, it will be sent to you, dear experts. You will then have 2 weeks to make corrections to the text or also make additions to your statements that have been recorded. The live stream that we have produced is available both in German and English. It's available on our website of the Bundestag administration, so that for you might be interesting as well to listen up on it. Now finally, I would like to take this opportunity again to thank all of you, Ms. Carlo, gentlemen. This has been a true enrichment to the work of our committee, and it has made sure that we can continue very positively our investigative work. Thank you very much again to travel from your countries to be here with us, and many thanks. Have a pleasant day. We have to stay on for a while.